I'd like to give each of you a minute or two to pretty much sum up the key takeaways that you have in this event. So I'd like to start with John Baumberger. John, can you give us some key highlights for our attendees to remember?
Well, I think first and foremost, being familiar with these requirements is key, and understanding how they apply, and so that it's not, a lot of times people face this as a mystery, and it's really not a mystery. It's not difficult to understand. And it's designed, the Act is really designed for self-policing and self-guidance. And part of the motivation, I think Scott went over earlier, is to open, especially public accommodations, to the 40 million people who face disabilities in the country, who are consumers, who are customers. And so looking at it from that standpoint, and using, many companies use accessibility as a marketing feature as well. I mean, not as a burden. The other thing I would mention is that it is also very, very, I think, beneficial to be proactive. I think Scott touched on this several times, and that is, to the extent that you can, especially with a website, adopt an accessibility policy, adopt an accessibility implementation plan. For example, if you are with a website, if you are looking at a complete redo of your website, it is not expensive at all to include accessibility in that package. It can sometimes be expensive to retrofit a website, but it is not as difficult to do a new site. So if you're doing a new site, it's critical to understand that that's the opportunity to make sure that you're compliant, and then once you're compliant, you're in good shape. So I think understanding what your requirements are, and then being proactive to remove readily achievable barriers, plan for the future to remain compliant, and to make sure that you're in a position to defend yourself, and also utilize your accessibility features to improve profitability. Scott?
Thank you, John. Some key takeaways, Scott Claus?
Sure. Well, they're mostly going to be a recapitulation of what John said, so I'll try and synopsize them. One, for you litigators out there, more than in a lot of other types of litigation, it's important for you to recognize that you need to keep both of your hats on at the same time. You both need to be an advocate for your client in the litigation, but you also need to be a counselor for your client in helping them understand the ADA, helping them understand the guidelines to accessible design, and helping them understand what can and should be done post-haste. So that is going to be difficult for some of you, because it's always difficult to have both of those hats on at the same time, but in ADA litigation, that's important. The second key takeaway: remove the low-hanging fruit. Address the low-hanging fruit. Exhort your clients to address the low-hanging fruit to make it less likely that you will be a target for easy picking. When the next serial plaintiff does his stroll down the street using Google Street View, if you have van accessible spaces, van accessible signs, the proper ratio, the proper dimensions, just like somebody who breaks into cars, it's easier to break into a car that's unlocked than it is to break into the one that's locked. So have your client remove that low-hanging fruit if possible to make your client's facility less attractive. And three, develop a relationship with someone who is competent and experienced in ADA compliance, an expert, an architect who is experienced and competent in ADA compliance, because it's important that you have a resource available to you if your client is the target of a demand, if your client is the target of litigation, or if your client is in the process of acquiring property, to be able to refer them to that compliance expert to assist your client.